everyone, and welcome to the daily newspaper analysis, which is brought to you by LawSikho. So today we have an article for our discussion, which has been taken from the Hindu newspaper. The title of this article is "The Shackles of 1861 Need to Go." So this basically is about the recent remission that has been given in the case of Bilkis Bano. So what was the case? What has happened? What is the legal progress over here? We'll be discussing in this article. Further, we'll be winding up with the news update and legal news for the day. So basically, the Gujarat government released the 11 convicts in the Bilkis Bano murder and gang rape case of 2002 under its remission and premature release policy. So basically, as we know that the president and the governor will, of course, discuss it further, have the power of pardoning, and under which they have one power to remit the punishment as well, under which they can, absolve the entire punishment for that matter. So recently, they have now put out, or they have remitted the 11 convicts in the Bilkis Bano murder and gang rape case of 2002. So this happened after Radheshyam Shah had moved to the Supreme Court for having been in jail for 15 years and 4 months continuously. So under Article 72 and 161, as we all know, the Indian Constitution, the President and the governors respectively have the power to pardon, suspend or remit the sentences passed by the courts. Now, since prisons are under the ambit of the state, therefore, similar powers are imbued to the state under Section 432 of the Criminal Procedure Code as well. Now, here we need to understand that there are various kinds of pardoning power. They can either completely pardon it, they can remit it, they can suspend it as well. And that is why here is a small task for you all. If you understand the difference between all these terms, you pause the video and let me know in the comment section as to what is the difference amongst these all different kinds of actions that can be taken by the president or the governor. Now here it says that since the prisons come under the ambit of the state, they're in the state list. So similar power has been given to the states as well under Section 432 of the Criminal Procedure Code. Now, however, Section 433A imposes a restriction on such actions if the convict has been sentenced for an offense where death penalty is one of the actions, or if the punishment has been death penalty itself. So if at all, the penalty that was given was of death penalty, so under Section 433A of the CRPC, there will be restriction on the actions of the state that such remittance or pardoning cannot be granted. So the grounds for remission were laid down by the Supreme Court in the case of Lakshman Naskar versus Union of India, which was a case of 2000. And it was held that whether the offense is an individual act of crime and does not affect society. So basically here we'll be studying as to what can be the grounds where such remission can be granted. So firstly, if the offense was an individual act of crime and it did not affect the society as such. Secondly, whether the crime can be repeated in future or not. Thirdly, whether the convict has lost the potentiality to commit crime. Fourthly, socio-economic condition of the convict's family. Or next, whether any purpose is being served by keeping the convict in the prison or not. And if not, then he can be definitely released. So the advocate in this case, who had been representing Bilkis Bano, has stated that the only legal recourse left for her now would be to challenge this government order that has granted such remission. And also it is important here to note that the process of remission is not that of the judiciary, but of the executive. And hence, the decision depends on the resolutions passed by the advisory committee. And that is why here definitely there can be a mix-up that we might get to see, and the separation of power definitely is at question at this point of stage. Next, let's move towards the news updates for the day. Firstly, Durand Cup begins. So Asia's oldest football tournament, Durand Cup, has kicked off its 131st edition in Kolkata. So the Union Defence Minister Rajnath Singh and Chief of Army Staff General Manoj Pandey visited Manipur to witness the inaugural match held at Khuman Lampak Stadium situated in Imphal. Secondly, FIFA suspends the All India Football Federation. So FIFA has banned the AIFF under citing undue influence from third parties as the reason. The centre made an urgent request in the Supreme Court for an early hearing as reports emerged that FIFA has suspended the All India Football Federation, leaving the prospects of India hosting the Under-17 Women's World Cup in October bleak. Thirdly, Freya, the walrus, has been killed by the authorities. So Norway has euthanized Freya, the walrus that had drawn crowds of spectators in the Oslo Fjord after concluding that it posed a risk to the humans. The 600-kilogram female walrus became a popular attraction in Norway in recent weeks. Let's see what do we have for legal updates today. Firstly, Talaq-E-Hasan, not so improper prima facie. Women have option of khula divorce as well, says the Supreme Court. The Supreme Court observed that the practice where the Muslim man could divorce his wife by stating talaq once in a month for a continued period of 3 months, according to the Muslim personal law, was not improper, and this was held in the case of Benazeer Heena versus Union of India. So for your convenience, let me tell you that when we talk of khula also is a form of divorce that is. So for your convenience, let me tell you that khula also is a kind of divorce which is available in the Shariat law or in the Muslim personal law. So basically, when Talaq-E-Hasan or talaq is the basic divorce that is brought forward by the husband, khula is a form of divorce where the woman or the wife initiates the divorce. So here it says that the women also have the option of khula in such a case. And this was held in the case of Benazeer Heena versus Union of India and others. Secondly, disclosure statement of co-accused under Section 27 Evidence Act, not legal evidence, qua a non-maker accused, says the Bombay High Court. The High Court recently stated that a disclosure statement of co-accused made under Section 27 of the Evidence Act cannot be deemed legal evidence qua a non-maker accused. This was held in the case of Raju Jokhanprasad Gupta versus State of Maharashtra. So this was all for today. We hope you liked the session. If you did, you will like it. Also, if you wish to download the PDF of today's slides, you can join our Telegram channel. The link to our channel is there in the description box below, or you can also scan this QR code that you can see on your screens right now. Thank you so much.